I'm Jason Harrow. I'm here with Charlie Gerstein. And Charlie, there is and ought to be in this great country the freedom to say goodbye. But there is also the freedom to say hello. So I say hello to you. Welcome to Versus Trump, the podcast where we talk about how the Trump administration is breaking the law and what people are doing about it. And Charlie, do you know what judicial opinion that first line is from?
I do.
It's one that we're going to talk about today. Excellent. The case,
yes, it is.
Dear listeners, and Charlie, is called Ravi Rugbeer against Jefferson Sessions III, as well as several other federal government officials. And Isha is not with us, even though she is an immigration specialist. But we're going to soldier on to talk about this really interesting immigration case without her. So sorry, Isha, she can answer some questions over email, or we can readdress any questions you listeners have next week.
Yes, we will almost certainly, almost without a doubt, fuck something up during this. And if Isha had been here, we wouldn't have. Isha had a work emergency. We were planning to have her on the show today. And so we have to soldier on without her. And we apologize to our listeners for our preemptive stupidity.
That's right. But so that first line, Charlie, let's just get right into it without much pretense. Because the listeners know where to find us online and on Twitter and on email, and we'll do that at the end of the show. But so in the Rugbeer case, that's the first line, right? The first line is that in this great country, there ought to be and there is a freedom to say goodbye. And that freedom to say goodbye comes in the context of an alien, a Trinidadian, who at one point was permitted to live legally in the United States, but was convicted of a crime and served a fairly long prison sentence, and even though he seems to have been rehabilitated, has for many years been subject to removal at the apparent whim of the federal government. And that's what's happening here until the judge in this case in the Southern District of New York blocked the removal, and it set off a firestorm yesterday. So Charlie, why don't you kind of fill in some more details and talk about who Ravi Rugbeer is, who the judge is, why he was here subject basically to the grace of the federal government, and then what happened on January 11th that took that grace away.
Okay, I'm going to spin a yarn here.
Yes.
So Ravi Rugbeer is not merely an alien present in the United States. He is also a leading advocate for aliens present in the United States, otherwise known as immigrants. He is an immigration activist and a outspoken voice for liberal immigration reform and for the human dignity of immigrants in the United States. That strikes me as a not incidental fact related to his abrupt removal, but we'll talk about that in a second. So he's been in the United States for 27 years. For a long portion of that time, he was a lawful permanent resident. Starting in around 1994 until his criminal conviction in about 2000, he was a lawful permanent resident, that is a green card holder who enjoys almost all of the protections of a United States citizen, except that he can be removed for, among other things, conviction of an aggravated felony. So in around 2000, he's working as a telemarketer for like a mortgage company, and some guy offers him a whole bunch of loan documents, and he doesn't really look too carefully into it, and one thing leads to another, and he's convicted of criminal wire fraud. He's currently moving to vacate that conviction in the District of New Jersey well after the period of time in which convictions are ordinarily vacated, but that petition remains pending. In any event, he's sentenced to 30 months in prison, 2.5 years in prison, which he serves. And upon his release, he is transferred to ICE custody, Immigration Customs Enforcement custody, pending his removal from the country. He's served with something called a notice to appear, which is like the charging document in a removal case for an alien who's deportable from the United States. And after that, he is detained for something like 9 months, pending the determination in immigration court of whether his conviction qualifies as, quote, an aggravated felony, which under the immigration laws is the kind of felony for which you can be deported, and it includes a conviction for fraud resulting in loss of more than $10,000. It appears that Mr. Rugbeer's convicted fraud resulted in a loss of over $350,000. And so he was convicted of aggravated felony, and the immigration court orders him removed.
Yeah. So Charlie, let me just jump in here really quickly, because I get the question a lot of what happens when people who are not citizens get convicted of serious crimes. This becomes familiar for folks who have had the privilege of clerking in federal court or in any court and seeing the criminal justice process. But it turns out that, as you know, Charlie, folks in this situation typically, absent extraordinary circumstances, actually serve out their full prison times in the US, whether in federal court or state court. They don't get any kind of credit, nor do they really get any extra time because they are here illegally unless they're charged with some kind of immigration violation. But then when a US citizen would just get out of prison and, as we've seen in the movies, kind of get a little bag of stuff and open some gate and be able to go home, these people are typically transferred into federal immigration custody, where they basically go to a prison-like setting, even though their sentence has already expired. So, Charlie, that's what you're talking about here, right? He serves his regular time in a regular prison, just like anyone else in the country, and only then would he go into the immigration process to eventually be removed. And so, in a sense, you kind of end up serving a somewhat longer time in detention than you would be, because that process only starts once you serve your full sentence.
That's correct. Although it can start while you are serving your sentence. And one thing that federal criminal defense lawyers do is attempt actually to start removal proceedings while a person's criminal sentence is pending, particularly if the person is not going to contest removal. So sometimes if you're convicted of an aggravated felony, you sort of have no grounds to contest really in a lot of circumstances. And people figure, I'd rather just go back to my country of origin rather than sit in immigration detention even longer. But Mr. Rugbeer has substantial attachment to the United States. His family is here. His children are here. He has since been released from immigration custody, has been married, and he didn't want to go back to Trinidad and Tobago. And so he decided to fight his immigration case and remained in immigration custody for another 9 months. Then he was ordered removed and filed a petition for review in the Board of Immigration Appeals, which was denied. He then exercised his right to have that reviewed in the Second Circuit Court of Appeals. And while that was pending, ICE decided to release him into the United States pending periodic check-ins. For a while, he had a GPS ankle monitor, and then eventually he didn't need that anymore based on several rounds of internal ICE review. And this happened in 2010. So he's released from custody into the United States in 2010, pursuant to a policy that basically, while your review is pending in the courts of appeals, ICE would agree to forego your removal under this policy. And if they're going to agree to forego your removal and you're going to be in the United States for a long period of time, they have to eventually release you if there's no reason to believe that you're going to flee or not appear for your final removal. So they release him at that point. And, this is a discretionary release. And he gets a little notice, and this is important. The notice says, we can revoke this at any time. You are subject to removal, but you're going to be here for a while. And in a separate matter, we're going to authorize you to work in the United States. And importantly, we will give you an opportunity to prepare for an orderly departure, which means when it's time for us actually to put you on a plane and send you to Trinidad and Tobago, according to this notice, we will give you an opportunity to tell your family and say goodbye to people and do all the ordinary stuff that you do. Doesn't say how long that opportunity is going to be. Doesn't say when it's going to happen. Doesn't really say what it's going to entail, but it does say it. So in the intervening, there's more. So when he's released, he's given this notice. And in the intervening 8 years, he periodically goes back to ICE and asks for a continued stay of removal. And he gets them every time. And in this period of time, he becomes a leading voice for immigrants' rights in New York. He gains the support of members of Congress, members of the city council, all kinds of community leaders, and he's doing all sorts of excellent work with his nonprofit organization and living a happy life in the United States. And on this goes basically up until the present moment. And then, Jason, come the events of January 11th. And I don't know if you want to talk about that or
yeah, sure. So January 11th is where I can pick up the story. And that is Mr. Rugbeer's most recent check-in and his first check-in under the new Trump administration immigration enforcement regime. And there are indications that he knew that he'd heard about people in his situation being removed rather than granted additional stays like the Obama administration had done, though, Charlie, as we can talk about, the Obama administration also removed many millions of people, in fact, more than his predecessors. So the Obama administration was clearly removing many people, but also giving stays when it was hard to find travel documents or when there was someone like this who was clearly rehabilitated and a productive member of the community and had very substantial ties to the United States, like with children and spouses and things. So nonetheless, he was concerned that the Trump administration would change course, and they did so very abruptly. So as the government's brief describes, they basically said, not only is your stay of removal up, but we've obtained a travel document for you. That travel document expires in 3 days on January 14th. So we're getting you on a plane right now. No chance to say goodbye, no chance to do anything. You're flying to Miami, and from Miami to Trinidad and Tobago. Adios.
And so just to jump in about what a travel document is, because before this case, I didn't actually understand how this process worked. So I'm glad I read the papers here. When you're subject to an order of removal, that doesn't bind the country that you were born in, or in the country in which you have citizenship. They don't have to accept you. And we have relationships with countries that eventually require them to, but that requires some formal documentation. And that can sometimes be more difficult than you would think. So in order to get Mr. Rogbier to Trinidad and Tobago, the United States government needed a document from the Trinidadian consulate in New York authorizing him to go to Trinidad and Tobago. And it appears that they did not have one.
Yes. What about the Tobagan consulate?
Oh, yeah. I don't know. I think it's the Trinidadian consulate.
Presumably the Trinidadian and Tobagan consulate.
I don't know. I thought the demonym was Trinidadian, but you know what? I'm glad you corrected me on that one. But we're going to say Trinidadian to save us some time.
I don't want to leave the Tobagans out. The Tobagans out. So, but yes, from this country, sorry to interrupt, Charlie, he needed official documentation.
Right. And it appeared that ICE did not have such documentation until January of this year. Is that right?
That's correct. So the papers say that they obtained a travel document that was good from January 3rd of 2014 to January 14th of 2018, to January 14th of 2018. So these are pretty strict travel documents, and Trinidad and Tobago gave the US government a pretty short window to actually remove Mr. Rogbier to the country. And so ICE moved with no advance warning and lots of speed. And
indeed, they missed an opportunity for advance warning. Rogbier's lawyer on January 8th speaks to the ICE field office, and they say, as of now, we're currently considering his petition for continued stay. Right. So 3 days beforehand, they didn't say anything. And when he comes down to the ICE office, they have a little sort of, I wouldn't call it a hearing, but like a meeting, as it's described in the papers. And during this meeting, the ICE field officer explains to Mr. Rogbier and his wife that he's getting kicked out of the country, and he abruptly loses consciousness, is brought to Bellevue Hospital in New York, where he stays for a couple hours, I think, and then is brought immediately to Newark and sent on, and this is important, a 4:15 p.m. flight to Miami. This is important because it is at 4:13 p.m. that Judge Catherine Forrest in the Southern District of New York issues an order to show cause to the government and a stay of his departure from New York. And so 2 minutes before the plane's supposed to take off, she issues an order that would forbid them to send him to Miami. He's on the plane. He goes to Miami. By the time he gets to Miami, the government's become aware of that order. And they send him back to New York. And thus begins the federal habeas proceeding, in which he's represented by Washington Square Legal Services, including law students from NYU, whose names are Brittany Castle and Jeremy Cutting, one of whom appeared in court on Mr. Rogbier's behalf and apparently did an excellent job, because shortly after this hearing, Judge Catherine Forrest grants the order that we're talking about, which, at least temporarily, forbids the government from detaining Mr. Rogbier or removing him from the country.
Yes, exactly. So that's the story, and where we are now, and these things can move quickly. Indeed, they moved extremely quickly, as we just described for Mr. Rogbier, is that on January 29th, the court filed this opinion that said that the government had violated his due process rights by basically not granting him a right to say goodbye, not granting him the right that they had apparently promised him many years ago, which was, once we get travel documents for you, you have a right to an orderly departure, not a sudden departure. And so he is now currently in the New York area. He is free of detention. He has given interviews to the media, and his case made national news. And we'll now see what happens, right? I don't know, Charlie. I haven't read this opinion only dropped about 24 hours ago, and I haven't read whether the government's going to appeal this, initiate a new proceeding. Not entirely clear what's going to happen here.
Yeah. And so as of right now, there is no travel document for Mr. Rogbier to be sent to Trinidad and Tobago. That expired on January 14th. So he is in an unusual status right now. He is released pursuant to order of the court, and the court has ordered that he be given an opportunity for orderly departure. However, it's unclear from the court's order whether ICE can't arrest him again, because now he's had the opportunity to say goodbye. It's unclear whether he can ever be removed, although the opinion appears to contemplate that he will be, although he certainly can't be removed right now because there's no travel document. And it would seem unlikely that the government can detain him between now and the acquisition of another travel document. So long story short, he's probably going to be here for a little while. Does that sound right to you, Jason?
It does.
And it's not 100% clear from the opinion.
It does. Though let's talk about the opinion itself and see what you think of it, because it begins and ends with a freedom that I didn't necessarily learn about in my constitutional law class, Charlie, but that we can talk about if it nonetheless has merit. And that is, as I began the episode with, the freedom to say goodbye. And that's also what Judge Fares ends her opinion with. In her conclusion, she says that constitutional principles of due process and the avoidance of unnecessary cruelty, an interesting phrase, here allow and provide for an orderly departure. Petitioner, that is Mr. Rugbeer, is entitled to the freedom to say goodbye. So what do you think of the freedom to say goodbye? Is it a constitutional freedom?
No. There are other freedoms associated with what happened here, among them the due process right for the government not to take away something that it has provided you, or to trick you into something, like by saying, we will provide you an opportunity to say goodbye and then not providing it. And that I find compelling. But as a general matter, and I think this is worth noting, throughout the Obama administration and during the nascent Trump administration, ICE practices extraordinary cruelty all the time, right? And this is a remarkable departure from that from the judicial sanctioning of that ordinary cruelty in every other dimension of the American legal system. So criminal defendants their homes are occasionally broken into in the middle of the night and they're dragged out in handcuffs, right? If you get a warrant for someone's arrest, that person doesn't get to say goodbye or ever go home again. And that happens all the time. People get picked up on the street, charged with a minor crime if they're discovered to be here in undocumented status, particularly if you're near the border. They sometimes actually just bring you to a bridge and push you over it into Mexico, right? This is an unceremonious process, and it's worth noting how violent it is in a lot of respects. Like, you are physically restrained and thrown out of the country. And I find it, I don't know, I'm puzzled by how it is that this particular individual is entitled to the right to say goodbye and no one else is, other than by virtue of the fact that the government told him he would have such a right. And that, I think, is compelling.
But let me understand what you're saying. I mean, so when you said that there is no freedom to say goodbye, let me start here and just get a sense of your position before I kind of break down what my thoughts are. When you say there is no, and you answered me no very quickly, but then described the cruelties of the government, are you saying that these are longstanding processes, they have repeatedly been challenged, judges and courts have repeatedly, even if they've expressed some sympathy for defendants or immigrant folks subject to deportation or removal, basically said that government has broad power in these circumstances to protect public safety and carry out orders of, taking people to jail and removing people from the country?
I think people don't even bother to have that conversation, right? And usually no one expresses sympathy. And I think that was part of the point I was making, is that this is a unique expression of sympathy and a unique expression of a right that most people are never afforded. And that is puzzling to me. And the reason I think it's not a generalized right is, to the extent we imagine it's to rephrase it, the government must provide notice before they physically restrain you and remove you from the country when you are subject to a final order of removal. That is just not a correct statement of the law. They can just pick you up. Right? If you're subject to a final order removal or are otherwise, and this is a different category, inadmissible to the United States, which is to say you never acquired legal status and couldn't have acquired legal status, you just get picked up, right? So in Trump's America, ICE just conducts roving raids where they find people and remove them from the country, including people who would fall within the DREAM Act, which is to say people who were brought here as very young children, right? They're just being thrown out of the country more or less en masse. And that's been happening for a long time. So I think we can fairly say there is no right to sort of pre-removal notice, if that's what Judge Forrest was after.
And you're saying that as a matter of what's what's going on in the country, this right doesn't exist. But should it exist, I guess? Maybe that's what you were about to get to. Could it exist?
Yeah, it certainly could, right? It doesn't, in any sense of the word, does or doesn't, right? There's no source of law cited in her opinion for it. There's a couple due process cases.
Yeah, there's due process
none
cases.
Really addresses this issue. Right. And it's unclear why that would cover this, right? He's had extensive procedures.
But I think Judge Forrest addresses that, right? She says the process that was due here is not process that will allow him to stay indefinitely. She says those processes have been had. He's taken a number of appeals. He was convicted of a serious felony and he was not a citizen. And so he is subject to removal. That much everyone agree. But what she says is that the process that is due is the allowance that he know and understand that the time has come, that he must organize his affairs, and that he do so by a date certain. That is the process required of a life lived among us. And I think that's a really interesting theory, right? Which is to say that the violation here is taking someone who has been the beneficiary of government grace. And that government grace cannot be arbitrarily revoked without notice, right? It would actually be one thing if he were taken, as we talked about, from prison and directly to Trinidad and Tobago. But it is the life lived among us, she says, that gives him more of an interest and a stronger right to this due process of notice of, hey, you're going to be removed tomorrow. We've got your document, say goodbye.
Yeah, although it's worth noting, and fair enough, and I think that goes into the same category as because the government told him he would have this opportunity, which is to say there's no freestanding right to say goodbye when you're a removable alien in the United States, but there can become a due process right after you've been given all these grace extensions and told you'll be given an opportunity to prepare.
Right, I think that's right.
But that creates a protected interest. That's different than there's some abstract right to say goodbye in this country. And I know that this rhetoric is being reported as quite beautiful and an important statement of our principles. And I only wish that were true, right? She says this is not how this country is supposed to behave and our country shouldn't do these things. And of course our country does these things. I find that sort of rhetoric actually quite damaging because it suggests this sort of golden past when this kind of thing didn't happen, right? And that this is a departure from the order. How could we treat people like this in America? It's are you serious? Do you know how people are treated in America every day? It just suggests that she herself, and I think this is something we're going to talk about in much greater detail, is a notably cruel judge, right? She has a reputation for cruelty. She sentences people to extreme periods of time. On several occasions, she has been reversed by the Second Circuit for sentencing people to longer than the sentencing guidelines, which is pretty difficult to get reversed for, and those guidelines are extremely long. In at least one circumstance, she was reversed and had the case reassigned to another judge because she threatened to make someone's sentence worse if she appealed it, right? This is really bad conduct. And it seems to me inconsistent with this broad proposition that American institutions generally treat people like removable aliens and criminal defendants with solicitude and respect when they do exactly the opposite and have for a really long time.
Yeah. I guess I don't share your cynical views, or perhaps I have more of a sort of realpolitik view of what's going on here, which is I start from a couple propositions. One is she's not addressing every case before her. It would be nice if she were Judge Gleason. There were a judge, now retired judge on the Eastern District of New York, who repeatedly wrote very broad opinions about the problem of sentencing in general, using harsh sentences that he was required to impose on particular defendants to really take a view of the system broadly. This is not that. It would be nice. There's a place for that, but that's okay, right? This opinion has to...
Wait, what do you mean this is not that? This is
not
sweeping
an overview.
Broad statements about the rights to say goodbye.
Yeah, correct. As applied to this case. She doesn't pretend. I don't take her as saying that this, trying to detail the outlines of this entire principle in all kinds of cases, nor that she is drawing on the practices of the Department of Homeland Security or ICE or the U.S. Attorney's Office or anyone else. It is true, I hear you, that she is perhaps willfully ignorant, perhaps not so willfully ignorant of the fact that this does happen in many other cases, and perhaps it has never been presented to her in so stark a terms, right? A clearly rehabilitated, indeed the government seems to agree, a rehabilitated immigration advocate who is a productive member of society with a wife and child who are U.S. citizens, being so shocked to be removed that he literally faints and is taken to a hospital to recover before being immediately placed on a plane, right? This is perhaps the most sympathetic case she has ever seen. But that's where these things start, right? I don't think it's realistic, Charlie, for us to think that judges are just going to, in the ordinary course, be presented with arguments based on kind of run-of-the-mill facts and create new and interesting legal theories and legal rights, which I think this could be.
So the only thing I demand is like some kind of consistency, right? Consistent application of the law, core principle of the rule of law. If this guy's entitled to the right to say goodbye, why aren't all the people that she has unceremoniously dragged out of her courtroom in chains every day entitled to similar treatment? And I think behind the scenes of all of this is something that weirdly doesn't appear in the papers, and I think might be motivating the different treatment here, and something that we talk about a lot on the show, which is why this guy, right? There's tons and tons of people subject to final orders of removal, and he wasn't arbitrarily removed. He was probably removed because he is an outspoken immigration advocate, and we know this because the co-founder of his organization was similarly removed in a similar situation only a few weeks ago. And meanwhile, tons of other people are just going about their business in similar status and not all being abruptly and immediately removed, although more have been, but not everyone. And so, there's an inference that's not crazy that what's happening here is discrimination against him on the basis of his protected advocacy under the First Amendment of other people's immigration rights. And I think that bothers the court. It surely bothers me. And that would have been, to my mind, the basis of a more successful habeas petition.
Well, it's in there, Charlie. I mean, I hear you. That the judge does say that she has grave concern that Mr. Ruggiero has been targeted as a result of his speech and political advocacy on behalf of immigrants' rights and social justice. It's true there's not a lot of evidence of it. That's extremely hard evidence to get. But I do think it's fair to say, Charlie, that this opinion would look very different and probably have come out a different way and at very least been written a very different way if the Obama administration had taken these exact same actions, because the specter of the Obama administration actively removing from the country folks who are immigration advocates would not hang so clearly over this case, right? As you said, Charlie, that is a cloud that is over this case and perhaps motivating a lot of what's going on. But I don't know. I mean, how can we get at that part of the claim, right? I mean, how can he show that, first of all, assuming, again, that he, like many others, is subject to an order of deportation and he can be removed at any time, does it make a difference why the administration is removing him? If it is because he's an immigration lawyer, if it were because he was a doctor, if it was, I mean, lots of people have lots of features.
If they're removing him because of his protected advocacy under the First Amendment, that's an obvious problem, right? If the reason they're removing him is his speech, then they can't do that alone. If they would have left him here other than because of his protected speech, that's a problem. If they're removing him because of his occupation, that's probably fine, although I don't think that's what we mean when we say we're removing him because he's an immigration activist. We don't mean that in professional terms.
And I just want to be clear.
In terms of his protected speech.
Right. And I just want to be clear. When you say an obvious problem, do you mean obvious problem to you? And I just ask, and I'm not an immigration expert, and you're not an immigration expert, and there is something that is very difficult about picking and choosing who is going to be deported based on their views, based on what they say about the Trump administration, which says a lot about immigration and immigrants. But that said, that's very, very hard to prove, very hard to say. I mean, given the amount of discretion, we've talked about this before, right? What happens when the government makes decisions within its very broad immigration powers that seem to be motivated by animus against people? Here, this is animus against individual people for advocating for immigrants' rights, right? Obviously, the Muslim ban, we had animus against people on the basis of their religion, not permitting them into the country. That was struck down, though recent iterations have been upheld. So that to me seems like a tough balance there. But if that's what's underlying it, it's a super interesting theory. And I do hope it goes somewhere in terms of that argument and gets fleshed out.
Yeah. And so, I mean, that's obviously something that's at least in the background here. And it's also, of course, as we said earlier, worth noting that it's not 100% clear the remedy that's been granted here. So he's out and he can't be removed right away. And so it wouldn't be clear, even if it were proven that they were taking these actions against him as a result of his protected speech, whether by those actions we mean removing him from the country, something that had legally happened in 2010, or abruptly removing him without notice, which it appears they've been doing to a lot of people. So who knows? So, Jason, should we talk about some of the actual legal claims, which appear in his petition but barely appear in the court's opinion. And maybe we should go through whether there's any merit to them.
Yeah, sure. Though that's to me what's fascinating about the court's opinion, right? It is a kind of musing on what constitutional law can be, what it should be, the way that the government ought to treat people, and it doesn't get bogged down so much in, statutory citations or legal citations necessarily. And I'm okay with that in some circumstances. Candidly, especially something like this, right? Before we get to that, I do just want to say about what's going to happen next. I mean, it seems to me that if the government gives him more notice and he's removable, and they obtain another travel document, and they give him a little bit of time to get his affairs in order, which he should now have, he can and perhaps should be removed, right? I mean, this is a person, like it or not, who was convicted of a serious felony, served serious jail time, and I just don't think there's any political or legal world in which we don't think that the government should have broad discretion to remove such people. Obviously, they can't do it on the basis of immigration advocacy. That's true. I do agree with that, or race or something like that. But to the extent that they are now making sure to capture all serious felons, this person is a serious felon.
Right. Just to be clear, there is a political world and a legal world. It is certainly not our current legal world in which immigration status, at least once you've achieved a certain high level of immigration status, like lawful permanent residency, should not be tied to criminal conviction status.
Okay, yes,
which
fair.
is to say,
I agree with that.
Right, like we don't practice banishment in this country.
I agree.
And once you've become a lawful permanent resident, right, that is, there's no doubt that is not the current world.
Yes.
Right. And so, in this world, right, he was convicted of a serious felony, apparently stealing a lot of money, something that he more or less maintains he didn't do. He was convicted of it. That conviction became final. I'm not going to address whether that's true or not. I don't know.
That's right. And just to clarify what I was saying too, Charlie, I agree that's not this world. And I was trying to perhaps venture into a political point, which we try not to do too often here on Versus Trump, though sometimes law and politics
we're totally
mix.
Apolitical here on Versus Trump.
But just as a matter of the kinds of policies that Democrats and liberals and immigration advocates should press and the hills that they might want to die on, right? It seems to me substantially left of the median voter to advocate for the rights of convicted felons to be permitted to stay in the United States indefinitely, who are non-citizens.
That is no doubt an accurate observation. And it's worth noting that the Obama administration's policies on, what they call illegal immigration, although people here in undocumented status aren't necessarily violating U.S. law, but to make the terminology as they do, is, we're focusing on dangerous people, right? Dangerous felons. Mr. Rugbeer was not convicted of a violent crime. That's a distinction worth observing. Nonetheless, I think even Obama would have classed him in that category. And so it is also worth asking why it took the Obama administration so long. I mean, the immigration system was hopelessly backlogged for a really long time, and it was just difficult to get anything done. That backlog has actually just been getting worse, although it's getting worse at a slightly slowing rate. So as a general matter, the entire immigration system was flooded throughout the Obama administration and well into the Trump administration. And so they might just not have been able to get around to getting this travel document. But there's also a chance that they just didn't want to do it because President Obama, who presided over more deportations than any president in American history, did not want the ugly spectacle of removing someone with the status of Mr. Rugbeer, who has justifiably earned a lot of respect in the community for his advocacy and is regarded more or less universally, although I'm sure this is not true on the right, as a good guy.
So, but can I press there? And I guess maybe at some point we should get to the legal claims, but I find that so interesting. If that is true, then isn't the Obama administration guilty of the very same viewpoint discrimination that
Absolutely.
You were accusing the Trump administration of? Okay.
For sure.
Which is to say, playing favorites with immigrants advocates rather than discriminating against immigrants.
Correct. So, yes, and the First Amendment implications are equally clear, which is to say all the people who have no obligation and can't be given an obligation to speak on behalf of other immigrants, they just get unceremoniously thrown out of the country.
Right.
And people who have the courage and the intelligence and the resources and the wherewithal to fight their deportations loudly, which is something I thoroughly commend and agree with, they are sort of rewarded for that in a way that people who don't have those opportunities or choose not to exercise them are not. Totally big problem, right? And I think that's also sort of simmering behind the curtain here, although, it's possible it just took this long to get this travel document.
Yeah.
It frankly strikes me as unlikely, and it strikes me as not a coincidence that they got one reasonably shortly after Trump took office, and that they somehow also got one for the other guy who founded the nonprofit with him, this is a circumstantial case to suggest they weren't looking that hard before the administration changed.
Yeah,
but,
that's right. And
under the legal claims, which we can dispatch with pretty quickly. Well, Jason has something to say?
I was just gonna say, Charlie, that to add additional evidence, this is not a smoking gun or anything, but Caribbean countries that the United States is on relatively good terms with, Trinidad and Tobago, Haiti, seem to me, I don't have vast experience with this, but there are other cases that you can imagine, more difficult countries that the United States has less of a relationship with, countries with less stable governments or that are hard to get in touch with, where it could prove genuinely problematic to obtain travel documents. Again, I'm not an immigration expert, but Trinidad and Tobago, the United States is on relatively decent terms. And it seems like if the Obama administration had wanted a travel document, it could have obtained one.
It seems that way, yeah. And any listeners who know anything about this are advised to write to us about it, because I would love to know how this process works in more intimate detail. And I was unable in the relatively short period of time that since this opinion came down, be able to get to the bottom of that. So let's crowdsource the hive mind here, and let's hear what the Versus Trumpers have to say. So tweet at us, send us emails, do your usual stuff. You know where to find us. And, let's talk about briefly what this guy's claims actually were. And first, it's that this statute does not authorize the government to detain him. That seems obviously wrong. We can dispatch with that reasonably quickly.
Yeah, and even the judge doesn't push back against that.
It was really so obviously wrong. I get why you try, but that one's just not right, and I don't think we can spend too much time there. The second is that the government has violated its own regulations, which is to say that the government appears to have imposed in certain parts of its own regulations a requirement that it not remove someone within 72 hours of his arrest, meaning that you must detain someone from 72 hours. Presumably that regulation is in place in order to double check and make sure that you didn't get the wrong guy, although periodically the government does regardless of that regulation. Problem is that regulation appeared to apply only to removals effected prior to 1997. Well, since after 1997. And in any event, failure to comply with their own regulations is not necessarily, as we've talked about in a lot of our other discussions and on which Isha is substantially more expert, it's not necessarily a ground to invalidate government action. And then comes the due process claim, which is the one on which Mr. Rugbeer actually prevailed. And the essence of that claim, and you would not get this really from the government's opinion, is having granted it, the government may not arbitrarily take it away. And it, in this context, is the opportunity to say goodbye and presence in this country as a matter of grace. She doesn't quite go so far as to say that. And as a matter of existing law, that would definitely be wrong. There's a lot of courts of appeals opinions about people in the status of Mr. Rugbeer, which is to suggest subject to a final order of removal, but released as a matter of grace into the United States and permitted to work. Those people, generally speaking, are not regarded as having a due process protection against their abrupt and, I suppose, arbitrary removal.
Yeah. And that's a great summary of them, but, just highlights how scary it must be. I mean, and that really resonates when thinking about this case, which is if you are I almost don't know what I would want if I were Mr. Rugbeer, right? Because being able to work in this country and live in this country where you have a child and a wife, obviously is an incredible privilege. But imagine going to bed every night and thinking it could all be over tomorrow. I mean, what a terrible state to live in.
It's absolutely awful. And I think putting people in that state, I mean, a lot of people just decide not to fight it and to just voluntarily go back, particularly depending on the country. A lot of people just choose to do that, and depending on their own personal circumstances, they choose to do that. It's obvious that he does not want to do that, right? He spent a tremendous amount of time in actual federal custody that he could have escaped from if he agreed to go back to Trinidad and Tobago. He obviously does not want to do that. There are many reasons why that might be the case, some personal, others political. He's devoted to the cause of immigrants in the United States, and I think a lot of this is related to that, although he recently told several magazines that he really has no desire personally to be an example here. He actually just wanted to chill with his kids and his wife and relax. And, he felt it was his obligation to speak out on behalf of others, although that obviously jeopardized his own status. But yeah, it's obvious to me that what he wants. It is unclear to me what I would want.
Really tough. And as with so much in immigration, it's just luck. I mean, Charlie, you and I were lucky to have been born here in the United States. And I mean, so much of government policy and what the government can do to you, especially these days under the Trump administration, is just the luck of the draw. And we're not here as political advocates for either side, because I'm not saying I know what to do politically, but the legal opinions just make that very clear.
Yeah, and let's all hope we're not looking up Canadian immigration laws pretty soon on versus Trump.
Yes, that's right. Okay, so that's it for our discussion of the Ravi Rugbeer case. We will get back to it if there's some more interesting developments. And, as of right now, like I said, your guess, Charlie, is as good as mine. And same thing, listeners, with what's going to happen. One mutual Trump nugget before we go, listeners, is just a recommendation for a fellow excellent podcast. Those of you that haven't yet found the podcast Slow Burn on Slate, about the Watergate scandal investigation, media relationship. It's a really comprehensive look at Watergate, sort of from the inside of Watergate in an interesting way, trying to do a tick-tock of what it really felt like when things were uncertain about what was happening with President Nixon, and giving it interesting analogies with our times where there is this ongoing investigation by a special counsel and we don't know what the outcome will be. How would it feel to be there at that time? That's the question that the host keeps asking, and it's a great listen and very relevant for a lot of the stuff we talk about. Charlie, any thoughts on Slow Burn?
Yeah, it was really good. I just listened to what I think is the last episode this morning, and I recommend it to all y'all, except not as a replacement for Versus Trump, only as an addition to Versus Trump. Correct. Meanwhile, I get the sense that anybody who's listening to this show has dug deep enough into the world of podcasts to be well since familiar with Slow Burn, which is substantially more popular. Just not to say we're not popular, but keep listening to us and also listen to Slow Burn.
Yes, that's right. And I love the idea that of going back into the time, right, where history always feels inevitable because we know the answer. It's like once you've seen the movie, it seems completely different. It's hard to go back to not knowing the ending of The Usual Suspects, which I won't spoil here.
Oh, yeah. And, we just sort of, I think as modern listeners, at least I really didn't realize, although I was familiar with these dates, how long the whole thing took.
Yeah.
And how long it took before it became clear that it was going to be really bad for him.
That's a great point.
And that I think is worth reflecting on these days.
It's a great point, and it highlights to me just how extraordinary it would be for Republicans at this early stage, with so much unknown about the president and his involvement with Russia and his obstruction of justice, to meaningfully turn on the president, right? It's just so many Democrats are condemning Republicans for not doing so, but this to me gives such definitive proof it's too much of an ask. Right. It takes it's something absolutely extraordinary for folks who are loyalists to the president, to the most powerful person in the country and in the world, to turn on that person. And it's just not going to happen without.
Oh, we'll have episodes about that, folks. We're not talking about impeachment now, though, I'm afraid.
Correct.
And so
we're talking about
with that, we will leave you with our contact information. Jason, shall we?
At Versus Trump Pod on Twitter, Versus Trump Podcast at gmail.com by email. You can rate us on iTunes or in other players. And you can also find us online at takecareblog.com/podcast, where we put lots of show notes and links, and we'll have links to the opinion that we discussed here today. Until next time.
The red light of the train